I agree that there is need to send a clear message to the police that their duty is to protect life rather than to take it away. I have seen the condition of the fourth accused person. He is an invalid. However, it would not meet the interest of justice if I fail to jail him to a term in prison. All the accused persons deserve to be jailed to a custodial sentence. That is the only way a clear message would be sent out to the public and especially the police. This judgment is the sad and tragic record of the death of Alexander John Runan Manson, whom we refer to as the deceased, a young man aged 28 years old of a British aristocratic dynasty of Baron. The young man came to Kenya and lived with his mother in Diani, a scenic, calm and windy beach in the Kenyan south coast. Having recently completed university, Alexander was at the prime of his youth, looking forward to a promising future, whether in Kenya or in Britain. Unfortunately, on the night or morning of 18th/19th of May 2012, the young Alexander was arrested in what evidence shows a healthy condition, placed in a cell overnight and woke up to his death in the mid-morning of 19th of May 2012. What happened to Alexander was not altogether a surprise to most Kenyans. Police cells have in the past become death traps for inmates, most of whom have as their only crime the fact that they were suspected by police to have committed a crime. The circumstances leading to the death of Alexander were investigated through a public inquest in the Diani Inquest number 3 of 2015 under section 386 of the Criminal Procedure Code. The inquest, by its ruling delivered on 23rd of June 2018, recommended the prosecution of Naftali Chege, Charles Wangombe Mnyiri, Ishmael Baraka Bulima, and John Pamba, who were subsequently charged with the murder of Alexander under section 203 as read with section 204 of the Penal Code, chapter 63, Laws of Kenya. Article 6 of the Code of Conduct for Law Enforcement Officials states, law enforcement officials shall ensure the full protection of the health of persons in their custody, and in particular shall take immediate action to secure medical attention whenever required. It came out clearly during the cross-examination of the accused persons by learned State Counsel Mr. Muteti that the accused persons were all professionally trained and had been in service for periods ranging from 3 years to 37 years. They had adequate knowledge and experience on how to treat suspects. They were trained in the rules regarding human rights and dignity. They were all aware of the Constitution of Kenya and statutory regulations concerning the rights of arrested persons. They knew the rules and regulations under IPOA. They were schooled and trained in international, regional, and local safety legal instruments for treatment of offenders. All of them testified to this training. However, they chose to do their work with the usual casualness without any regard to their profession and the duty to protect life. To them, these legal instruments were mere rules with no consequences whatsoever. The four accused persons, starting with the second accused, the senior most among them, let down the entire police force. Although he had served in the police force for over 37 years, the second accused let down Alexander John Runan Monson, the deceased, at his greatest hour of need on earth. How four senior police officers could allow the death of a young man of 28 years die under their watch is the tragedy of this judgment. Having considered the mitigation in place, it must be noted that the sentence for manslaughter is life in prison. Therefore, any term that derogates from life in prison is already a win for the accused persons. I therefore herewith jail the accused persons as follows, depending on their degree of responsibility. The first accused person, Naftali Chege, is sentenced to serve a jail term of 15 years in prison 5 of which are suspended. The second accused person, Charles Wangombe Munyiri, is sentenced to serve sentence of 12 years in prison, 6 of which is suspended. The third accused person shall serve 9 years in prison, 5 of which are suspended. The fourth accused person shall serve 12 years in prison, 6 of which are suspended. However, due to his invalid condition, the fourth accused person shall continue to seek treatment outside the prison and shall only move into jail after his health condition has improved. However, in any event, the fourth accused person shall move into jail on 15th of November 2022, regardless of whether or not he shall have healed. That's the judgment of the court.